People have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele. This is gross. This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night.
What the hell was he talking about? Well, finds out there's paperwork on what the hell he's talking about. Check this out. Incident which occurred on or about October 2nd, 2023, when Judge Glanville initiated a contempt hearing against undersigned counsel Max Sharp, attorney for Mr. Stillwell. On this date, Judge Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him on some bullshit in open court. While in chambers, undersigned counsel was advised that he should not deny the accusations, and it was all captured on video. When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later that day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. In the end, attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that captured the event was never produced and no apology was made.
Hey yo, what the fuck?
But wait, there's more. Hang on to your seat, baby, cause this one's a screamer.
Readily apparent examples of error, impropriety, prosecutorial misconduct, and judicial partiality. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. As detailed in depth in co-defendant Williams' July 10, 2024 motion for a fair trial, the prosecutors of this case have repeatedly failed to follow the orders of the court, have made specious allegations against defense counsel, and have lacked candor to the court. This case has been plagued by improper legal rulings, included but not limited to an overly liberal and unconstitutional application of OCGA 801D2E. Defense counsel has routinely been cut off by the prior trial judge when arguing these matters, and rulings have been made with little or no analysis. This case had also been exceptional in the mistreatment of defendants and defense counsel. Examples include, but are not limited to, an incident which occurred on or about October 2nd, 2023, where Judge Glanville initiated a contempt hearing against undersigned counsel Max Sharp, attorney for Mr. Stillwell. On this date, Judge Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him on some bullshit in open court. While in chambers, undersigned counsel was advised that he should not deny the accusations, as it was all captured on video. When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in that day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. In the end, attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that captured the event was never produced and no apology was made. Judge Glanville has repeatedly demanded that certain defense counsels, included but not limited to undersigned counsel attorney Brian Steele and attorney Carlton Matthews, to sit down in a terse and abrupt manner when overruling valid objections, all if in front of the jury. These incidents have been too numerous to document individually. Judge Glanville has sustained specious and frivolous vagueness and facts not in evidence, arguments from the state that has effectively cut off the defense's ability to conduct thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel's attempts to effectively cross-examine investigator Tyrone Dennis. Judge Glanville, on two different occasions, basically called attorney Brian Still unprofessional and unprepared in front of sitting jury. When it was shown that Judge Glanville's comments were completely off base, Judge Glanville refused a defense request to issue an instruction that jurors should disregard his comments about Attorney Steele. Judge Glanville has monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse through security cameras for no permissible purpose and without cause. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis. It has repeatedly misstated the law covering reciprocal discovery, all to obtain an unfair advantage from Judge Glanville. The state has gone so far to contact non-attorney members of the defense team and demand that they provide certain items to the state without consulting with defense counsel first. These actions were taken without any legal basis and were an attempt to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. The state initially and erroneously accused Attorney Steele of tampering and altering jail calls made by Kenneth Copeland, which were severed in reciprocal discovery. Or, of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. On June 10, 2024, Judge Glanville held an illegal contempt hearing against Brian Steele. Judge Glanville briefly incarcerated Mr. Steele. We're not really going to get into all that because this is all basically repeating the same stuff. So neither Judge Glanville nor the state revealed these ex parte communications that occurred. Yeah, we're not reading all this crap because here we go right here. I think I really wanted to read this one. On July 30th, 2024, Honorable Judge Whitaker presided over substantive matters of this case for the first time. The Honorable Judge Whitaker provided much-needed clarity to the defense, releasing the rough draft of a transcript of an additional ex parte communications between the prosecution and Judge Glanville. The ex parte meeting occurred on June 7, 2024, and included Love, Hilton, and Judge Glanville. These communications and the substance thereof had never been disclosed to the defense until the Honorable Judge Whitaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on a July 10, 2024 meeting. Instead, Judge Glanville and the state remained silent on this topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implication of June 10, 2017 as part of her consideration of motions filed to recuse Judge Glanville upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was, in fact, another ex parte meeting that had occurred 3 days prior. This was their secret. The transcript of the June 7, 2024 communications is shocking. It also sheds light on how this case has become irreversibly broken. As an initial matter, there is no stated justification for the ex parte communications. The meeting was initiated by the state. Neither Copeland nor his counsel had requested the state meet in private with Judge Glanville. The meeting itself was illegal. The state, in this meeting, intentionally and wrongly attacked the character of Copeland's attorney, Melnick, claiming that Melnick was not representing Copeland's interests. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner that they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interests of our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick before Mr. Melnick had inserted himself into the client's legal affairs. The prosecutors claimed that Melnick was not representing Copeland's interests is rich. As they were communicating with the person behind Melnick's back, the state had intended to call Mr. Copeland as a witness without granting him any sort of legal protection as a witness. It was only after Melnick inserted himself and advocated for his client that the state sought to grant Copeland's derivative use immunity. The irony does not end there. The state in this meeting claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client's affairs. At no time, however, did the state ever seek any non-custodial alternatives for Copeland should Judge Glanville hold him in contempt. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his client, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick had not planned his vacation around Copeland's testimony. This is a ridiculous accusation, as the state intentionally failed to communicate with Melnick and had not given Melnick any notice they were planning to call his client to testify on June 7, 2024. The state was clearly only concerned with Copeland's interests as long as they were directly aligned with their own interests. The state framed interest in Copeland's well-being to get a foot in the door to Judge Glanville's chamber, all in an attempt to initiate improper ex parte communications. Melnick was not the only attorney who was disparaged by the state and Judge Glanville in the secret June 7, 2024 meeting. Love claimed that she was in receipt of an email from Melnick sent to her at Hilton, but also other individuals that had been blind copied on the communication. The clear insinuation from the conversation is that it was Attorney Steele and undersigned counsel who were blind copied. Undersigned counsel does not make blind accusations, but neither undersigned counsel nor Attorney Steele were blind copied on any email between Love and Melnick. Later in that ex parte meeting, Love again brings up Attorney Steele and undersigned counsel, noting that we were included on the June 6, 2024 email from Melnick. Love and Hilton were also included on this email, in which Melnick expressed his client's decision to exercise his Fifth Amendment rights if called to testify by the state. It is unknown why Love feels she should have a monopoly on information, or why she feels the defense's attorney should not be included on discussion concerning these matters. Undersigned counsel would like to inquire about these matters with Love sworn in as a witness. Judge Glanville abandons impartiality and echoes Love's thought, asking why would he, Melnick, have done that given sick? Before 88 Hilton responds, and that's the state's concern. Love affirms. That's the point. Rough transcript, page 8. As Judge Glanville had questions, so do I. Undersigned counsel asks why my inclusion on this simple email communication was a concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this material false and made-up situation, as if one exists, and tell Judge Glanville that she will contact him when she finds a solution, either over the weekend or on the coming Monday, presumably through additional ex parte communications. That's hilarious. Oh, man. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to outside agitators affecting the trial, stating, but I see it from just being in the courtroom and tracking Judge Glanville concerns and inherent skepticism of email communications between Melnick, Attorney Steele, and undersigned counsel exemplifies Judge Glanville's bias and partiality towards the state. The transcripts of both June 7, 2024 and June 10, 2024 ex parte meetings shows Judge Glanville clear bias against Attorney Steele and undersigned counsel, and finally provide an explanation, albeit an unacceptable one, Judge Glanville's treatment of the defendants and their counsel throughout this trial. We're not going to read all of this crap. We just gonna get right here. Remedies. Mr. Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error. In this case, focusing solely on the ex parte communications, the prosecutors and the trial judge team to coerce and intimidate Copeland to change his mind and testify for the state. Copeland's testimony was harmful in itself, but does more than that. As a result of this coercion and intimidation, the state has and plans to continue to impeach Copeland with his prior inconsistent statements, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stillwell and others. These out-of-court statements involve several of the charged events and counts in this indictment and are central to count 2 of this indictment, which alleged that Mr. Stillwell committed the murder of Donovan Thomas. Mr. Stillwell does not wish to demand a mistrial. Absent a finding of goading and thus jeopardy attached to Mr. Stillwell has been incarcerated throughout the duration of his counsel. He has been viciously attacked while incarcerated. He almost lost his life. Starting trial over again is not a viable option for Mr. Stillwell, despite persistent legal errors.
Hey, yo, you. Can you subscribe and turn on that bell, too? Because when you do, you're helping unbiased, independent news.
How the term go? Liar, liar, pants on fire, or the Brotherhood of the Lawyers. One of the two. But I'm going to go with liar, liar, pants on fire, Glanville. If you ever tell me that you have some information on me and it's recorded and I know I didn't do it, I'm going to let my nuts hang. Not just him. I'm going to let my nuts hang. What I'm going to say is, hey, didn't show it. Didn't do it. Y'all know me. They done gave it a little controversies about me and all that crap on here. Hey, here the paperwork. Can't say nothing else. So, if y'all don't know, because we didn't know, Sharp revealed that he almost went to jail. that he got threatened with jail time for something that he did not do. And I'm sitting there looking like, bro, I've been watching this from day one. I don't know what he's talking about. Well, it turns out that Judge Glanville was hard on for an apology because of something that Judge Glanville thought he heard and said this is some BS in court. Man, let me tell you something. Glanville, do you remember when you were saying this?
On YouTube titled Slime Shit, where the lyrics state, hey, this is that slime shit, hey, YSL shit, hey, killing 12 shit, hey, fuck a jail shit, hey, cooking white brick. I'm not new to this, hey, so I'm not new to this, hey, I'm so true to this, hey, I done put up a whole slime of 100 licks, slime or get slime. I'm in the VIP and I got that pistol on my hip. You praying that you live, I'm praying that I hit. Hey, this that slime shit. Fuck the police, fuck them in a high speed, 100 rounds in a Tahoe. I'm prepared to take them down. Got banana clips for all these niggas acting monkey.
So Glanville, when you cussing saying this is slime shit, fuck 12 shit and all this stuff and everything like that, what was that? That's why it's kind of funny and kind of odd, but whatever, man. Y'all, you full of it, bro. I tried to defend Glanville, thought he was doing a good job, but everybody can be perceived and deceived. So that's essentially what happened. And to the same 5 people who keep spinning this illustration in the comments, I don't want to block y'all, but eventually I will. If you are introduced with new information from something that you were holding on to, you'd be a fucking idiot to literally hold on to the old belief. If you get new information, you better change your mind, because if not, then you're an idiot. So the individuals that are in my comments that are writing the same stuff, oh, you're flip-flopping and all that. No, dumbass. It's called new information. That's like how some of you idiots will sit up here and learn something about somebody and then still deny it. I don't want to be like you. I'm not sorry. And you're not welcome here. So for those of you who decide to keep on writing it, we just going to get rid of you. Back to it. I was wondering for a while, like, why the hell Sharp kept getting treated like a little boy. Because he definitely was. If I would have said that judge had a vendetta against anybody and I were to list them, it would have been Sharp first, Steele second, Mack and Ass Matthews third, because I watched him take Matthews to task. He's scared. Glanville was scared of Keith Adams. I don't know what it is. Maybe it's that New Yorker in him or something like that. I have no idea. But Glanville was afraid to throw him in jail when he literally said, Judge Glanville, I have the same information, and I dare you to throw me in jail, lock me up, throw away the key. But he didn't. Wonder why. But either way that go, man, that's why you have the remedies that Sharp put in there, man. And because I kept wondering, I'm like, man, the judge seemed like she want to sleep with this dude. Like, what the hell going on? But at the same time, he had an actual grievance against the judge. And I'm going to be fair. He a better man than me. Because any chance I get to be petty, I would have been petty. And he has had his moments. If y'all remember when the judge said, stop saying, thank you, sir, when he basically would deny an objection. He was like, denied. And then Sharp would go, thank you, sir. And then eventually Glenn was like, stop saying thank you, sir, when I'm denying your motions. He said, all right, I will stop. Thank you, sir. And I'm like, this dude crazy as hell. But can't lie. Run it up. Was it theatrical? Was it dramatis persona, as Shakespeare would say, when Weinstein is Sharp, and still we're talking about the July 7th ex parte meeting? Hell yeah, it was. If y'all think that was 100% how they were feeling, y'all don't think they added extras on it, then you out your goddamn mind. And I'm not saying they were wrong, because I would have did it too. I would have faked a heart attack. I would have sat up there, I would have pounded the hell out of the table and grabbed my chest. And then literally would have sat back like, just let me get a glass of water. I probably would have burst into tears. That's what they getting paid. if what I'm getting paid, if I'm them, I'm crying. I'm literally crying right there. And I'm saying, I'm giving it my all. It's not fair. But I don't know, man. Share to keep your people aware. Subscribe, turn on the bell, stay notified, and I'll catch you on the next one.